Welcome back, everyone. Step out of the vehicle. Officer, why am I being detained? Because right now I can take you to jail and figure out the charges later. Don't test me. That line shocks people when they hear it on body cam footage, but it also exposes something dangerous about police encounters that most drivers do not understand until it's too late. What do you do when an officer starts escalating before you even know what you supposedly did wrong? Do you argue? Do you explain? Do you try to prove you're innocent right there on the roadside? Or do you protect yourself legally? Because one sentence can calm the situation down, and one bad sentence can hand the officer exactly what they need. Today, we are breaking down what officers are often looking for during tense roadside encounters, why threats like "I'll find something to charge you with" matter legally, and the exact words you can use to avoid making the situation worse while still protecting your rights. And this matters because people talk themselves into arrests every single day, not because they're guilty, because they panic. The moment an officer becomes aggressive, most people make one of two mistakes. They either become overly cooperative and start volunteering information, or they become emotional and argumentative. Both reactions can create problems. The first can give investigators evidence. The second can create additional charges like disorderly conduct, obstruction, or resisting, depending on the facts and the laws in that state. That is why you need a framework before the encounter happens, not after. One piece of knowledge can change how a situation ends for you. Subscribe now so you're prepared. Then share this video and tell me what you think about it in the comments. The first thing to understand is this: an officer threatening to find something is not the same thing as a lawful arrest. Police generally need legal justification for detention, searches, citations, and arrests. The exact standard depends on the situation. Sometimes it's reasonable suspicion, sometimes it's probable cause, sometimes it depends on officer safety concerns. But here's the trap. Even if the officer is completely wrong, the roadside is usually not where you win that argument. The courtroom is. Your goal during the encounter is not to defeat the officer verbally. Your goal is to avoid giving them more ammunition. So let's break down the first major mistake people make: talking too much. This happens constantly. An officer walks up frustrated and says, "Where are you coming from tonight?" Instead of giving basic identification, if legally required, and stopping there, the driver starts rambling. "I was just leaving my friend's house. We had a couple drinks, but I'm fine, honestly. I only live a few minutes away." And that's how ordinary conversations turn into investigations. People think silence looks suspicious, but legally, volunteering explanations can be far riskier. A calm response sounds more like this: "Officer, I would like to remain silent," or "I do not wish to answer questions without a lawyer." Notice the wording. You're not insulting the officer. You're not refusing lawful commands. You are clearly invoking constitutional protections. That matters, because courts often look at whether a person clearly invoked their rights or simply stayed quiet without saying anything. And there's another important distinction here. Remaining silent does not mean refusing lawful identification requirements in states where identification may be legally required under certain circumstances. Laws vary by state and by situation, but volunteering explanations is usually where people create problems for themselves. Now let's talk about the second trap: consent. This is huge because many searches happen not because police had a warrant, but because somebody simply said yes. Watch how fast these conversations move. "Mind if I take a look inside the vehicle?" Most people panic here. They think saying no automatically makes them look suspicious, but consent changes everything. If you give permission, you may waive important legal arguments later about whether the search was justified. That is why one of the most important phrases you can know is this: "Officer, I do not consent to any searches." Short, calm, clear. Not aggressive, not emotional, and the reason this wording matters is because it creates a record. You're not physically resisting, you're not interfering, you're simply refusing permission. Now, the officer may still search anyway depending on the circumstances they claim exist. Maybe they say they smell drugs, maybe they claim probable cause, maybe they say the vehicle will be impounded. Do not physically stop them. That's another mistake people make. They think asserting rights means physically blocking officers or grabbing property back. That can escalate fast. Instead, your job is verbal clarity, not physical resistance. Say, I am not resisting, but I do not consent. That sentence protects you in two ways. First, it shows compliance. Second, it preserves your objection to the search. That distinction matters later. Now here comes another critical point people misunderstand during these encounters: detained versus free to go. Many people stay talking because they don't know they can ask a simple question. Am I free to go or am I being detained? That question forces clarity. If the officer says you're free to go, leave calmly. Don't linger, don't restart the argument, don't demand the last word. Just leave. If the officer says you're detained, now you know the encounter has legally shifted into something more serious. And once you're detained, the smartest thing you can usually do is stop talking beyond basic compliance. People destroy their own cases trying to explain themselves, especially when emotions kick in. Here is what often happens next in these viral encounters. The officer becomes irritated that the person knows their rights. Then the citizen becomes irritated at the officer's attitude. Now both sides are escalating emotionally. That is dangerous because officers often interpret sudden movements, yelling, stepping forward, or refusal to comply with physical instructions as potential threats. Even if you believe the officer is wrong, sudden movements can completely change the encounter. Keep your hands visible. Move slowly. Announce movements calmly. If you need to reach for documents, say, "My registration is in the glove compartment. I'm reaching for it now." Simple communication reduces misunderstandings. And another warning here: do not confuse assertiveness with aggression. You can protect your rights without becoming confrontational. A lot of online videos cut out the moments where a situation escalated because someone kept interrupting, shouting, insulting officers, or refusing basic commands. Courts often look at the totality of the interaction. That includes the officer's conduct and the citizen's conduct. Now, let's address one of the biggest misconceptions people have. If I'm innocent, I should explain everything. No, innocent people talk themselves into trouble constantly. Because stress affects memory. People guess at timelines. They accidentally contradict themselves. They try to sound helpful and end up sounding deceptive. Investigators are trained to notice inconsistencies. That is why lawyers constantly tell clients to stop talking. Not because silence proves innocence, because talking creates evidence. And once statements are recorded on body cam, dash cam, or written in reports, they become difficult to walk back later. Now, what if the officer threatens arrest? This is where people often panic and start bargaining. "Please don't arrest me. I can explain. You're misunderstanding." But if the situation has already escalated to that point, your priority shifts to damage control. The safest language becomes, "I wish to remain silent." And if questioning continues, "I want to speak to a lawyer." Those words matter because they invoke legal protections clearly, not vaguely, clearly. And once you request a lawyer, continuing to volunteer information usually does not help you. Now, does invoking rights magically stop an arrest? No, and people need to understand that. An unlawful arrest claim is something courts examine later based on evidence, reports, video footage, witness testimony, and legal standards. The roadside is not the courtroom. You may still be handcuffed. You may still be booked. You may still spend the night in jail. That is why emotional roadside arguments are usually such a bad strategy. The goal is not immediate victory. The goal is long-term legal protection. And one more thing people rarely think about. Tone matters. You can say legally correct words in the worst possible way. Compare these two examples. "I know my right. You cops are all corrupt." Versus, "Officer, I do not consent to searches and I would like to remain silent." Same basic legal position, completely different outcome potential. Professionalism protects you. Calmness protects you. Control protects you. Now, let's address an important legal reality. Laws vary enormously by state, by department policy, and by the specific facts of the encounter. What officers can legally do during traffic stops, pedestrian stops, vehicle searches, and arrests depends heavily on circumstances. This video is educational. It is not personal legal advice. And if you are ever arrested or investigated, you should speak directly with a licensed attorney in your jurisdiction. But the broad framework stays remarkably consistent. Do not argue the case roadside. Do not consent to searches you do not want. Do not physically resist. Do not volunteer information. Do not make sudden movements. Ask if you are free to leave. Invoke your right to remain silent when necessary. Request a lawyer if questioning becomes serious. And remember this: the most powerful thing in many police encounters is not a clever speech, it's discipline, because officers cannot use words against you that you never gave them. And the next video is about another mistake people make during traffic stops that turns minor encounters into criminal investigations almost instantly, consenting to just a quick search because they think refusing will make them look guilty.